Judge orders Trump to reveal whether he will use advice of counsel. Defendants do not have to reveal this strategy in advance, but Judge Tanya Chutkan states her order would prevent delaying the trial. U.S. District Court Judge Tanya Chutkan ordered former President Donald Trump on November 8 to disclose whether he plans to use an advice of counsel defense in one of 2 criminal cases prosecuted by special counsel Jack Smith. President Trump has been accused of interfering with the 2020 elections and has pleaded not guilty on 4 counts. Time equals 400 Ms. greater than. On October 10, prosecutors filed a motion demanding he disclose whether he will use the defense, arguing that if he does it will waive attorney-client privilege for all communications. If the defendant does provide affirmative notice of that intent, he must also provide the required discovery to the government, Judge Chutkan wrote in her new order, which set a deadline about 1 month later than the prosecutors requested, in line with what President Trump's attorneys have said about when they would disclose such a strategy. Judge Chutkan is ordering that these privileged communications be turned over to the government by January 15, 2024, if President Trump plans to use the defense in court. For instance, attorney Kenneth Chesebro had written a legal memo for the Trump Organization outlining legal avenues to take to challenge the election results, including delaying the vote certification on January 6, 2021, and bringing the issue to the U.S. Supreme Court. Time equals 400 Ms. greater than. Mr. Chesebro had been charged alongside President Trump in a separate but similar case in Georgia, accusing the former president and 18 others of being part of a racketeering conspiracy. Communications between Mr. Chesebro and the Trump campaign have already been made public, via leaks and later court filings. Time equals 400 Ms. greater than. Judge Chutkan wrote, citing precedent, that the advice of counsel defense requires a defendant to introduce evidence that relied in good faith on the counsel's advice that his course of conduct was legal, and that he made full disclosure of all material facts to his attorney before receiving the advice at issue. Time equals 400 Ms. greater than. As such, this would waive attorney-client privilege and require those communications to be introduced in court. But because waiting until trial to invoke the defense, and comply with the disclosure obligations it triggers, could cause disruption and delay, some district courts have concluded that they nonetheless have inherent authority to order defendants to provide advance notice if they intend to assert the defense, she wrote. Other district courts, however, have concluded that they lack that authority. In this case, the question of authority is moot. President Trump's attorneys have said that if they decide to use this strategy they will provide notice at the time jury instructions are due on January 15, 2024. However, the defense attorneys have only requested that the notice deadline be set at the same time as the jury instruction deadline and asked to provide the disclosure, if applicable, on another schedule. The judge rejected this argument, saying the attorneys did not cite precedent for it. Notice without disclosure would have little practical value, and would inject undue delay into the parties' pretrial preparations, the judge wrote.